Assembly, members should equally note that anything said in the virtual platform is deemed to have been said to the House and may be ruled upon. All members who have logged in shall be considered to be present and are requested to mute their microphones and only unmute when recognized to speak. This is because the mics are very sensitive and will pick up noise which might disturb the attention of other members. When recognized to speak, please unmute your microphone and connect your video. As I speak and move from that point, I would like all members to check that their mics are off. Members may make use of the icons on the bar at the bottom of their screens, which is an option that allows a member to put up his or her hand to raise a point of order. This secretariat will assist in alerting the chairperson to the members requesting to speak. But when using the virtual system, members are urged to refrain and desist from unnecessary points of order or interjections. We shall now, honorable members, proceed to the order, which is a debate on justice and constitutional development, vote number 25. And having said that, let me welcome the Minister of Justice and Constitutional Development, Honorable Lamola, to open the debate.
Thank you very much, Honorable House Chair, Deputy Minister of Justice and Constitutional Development, Honorable John Jeffrey, Deputy Minister of Correctional Services, Honorable Inkosi Patekile Holomisa, ministers and deputy ministers present on the platform, Honorable Bulelani Magwanisha, the chairperson of the Portfolio Committee, and all members of the Justice and Constitutional Development and Correctional Service Portfolio Committee, and all honorable members of the House in this mini plenary, the Director General of the Department of Justice and Constitutional Development, Advocate Mashabane, distinguished guests. On the 18th of May 2020, I stood before our Portfolio Committee on Justice and Correctional Services to give a portfolio overview of our strategic plans 2020-2025, as well as the annual performance plan for the financial year 2020-2021. At the time, we were all reeling from the devastating impact of COVID-19, and I said, when we conceptualized these plans, our priorities sought to invoke a paradigm shift in our country, a shift to rebuild the capacity of the state, rebuild our ability to fight corruption, restore investor confidence, recalibrate the economy, and create much needed jobs. But as the African proverb goes, ikamva alaziwa, no one knows what tomorrow brings. We are now required to implement these plans on the back of COVID-19 pandemic amid a recessional economic climate. Little did we know at the time that we will be presented with a hugely challenging year while responding to the unprecedented pressure of global pandemic. We also had to contend with the debilitating ransomware attack in the past financial year. On the balance of these major challenges, we have been able to overcome. Honorable members, I would like to take this opportunity from the onset to condemn the racist incidents that continue to raise their ugly heads in some of our high schools in the country and in some of our universities, in particular, the University of Stellenbosch recently. The university must leave no stone unturned in investigating the incident. All of us must send a clear and unambiguous message that there is no space for racism in our country. Parents must teach their kids love and to embrace diversity and not racism. White parents in particular have also a duty to embrace diversity and to spread love, same as Black parents. Recalibrating our economy needs all our efforts, and it also needs the criminal justice cluster. At the end of the fourth quarter of 2021 statistics, South Africa reported an increase in our real gross domestic product, which took our annual growth rate in the last financial year to 4.9%. I mention this because the budget allocation of the Department of Justice and Constitutional Development for the financial year 2022-2023 amounts to 22.4 billion rands. This is an increase of approximately 515 million rands. This budget must enable the state to fight crime, to create a conducive environment for investment, and to create jobs. This administration has taken a clear step to reinvest in the justice system. The allocation will help to accelerate the extensive work already underway to recover from the unprecedented impact of the pandemic while delivering a more efficient and modern justice system. The budget is inclusive of the allocation of the National Prosecuting Authority and the transfer to the two constitutional bodies, namely the Public Protector and the South African Human Rights Commission. The budget allocation also provides funding for the Information Regulator, as well as the transfer to the Legal Aid South Africa, the Special Investigating Unit, and the direct charge to the National Revenue Fund in respect of magistrate salaries. This budget enables the department and its entities to execute their respective constitutional and statutory mandates. Legal Aid South Africa budget allocation. Honorable members, Legal Aid South Africa has over the years rendered legal services to many South Africans who are unable to afford legal costs, thereby ensuring that the right of accused persons enshrined in Section 35(3) of the Constitution, in particular, becomes a reality. During this financial year, Legal Aid South Africa is allocated 2 billion rands, and Legal Aid South Africa is one of the few entities in government which is distinguishable honor of being recognized among the top employers in South Africa for the 13th consecutive year. Legal Aid South Africa increases its threshold for the means test to increase its reach in society where the cost of legal representation is expensive. Legal Aid South Africa has increased the threshold of its means test. The threshold for means test legal aids have increased. As a result, access to justice can be expanded to those who cannot afford it. In terms of the new regulations which have been in effect since 1 April 2022, legal aid for criminal case, irrespective of whether the applicant is a spouse or is a member of a household, is increased from 7,400 rands to an amount of 7,700 rands. This increase also applies to civil matters for individuals who do not have a spouse. For individuals with spouses, there's an increase from 8,000 rand to 8,400 rands in civil cases. For individuals who are members of households and do not own immovable property in civil or criminal matters, their net movable assets increased from 128,000 to an amount of 141,900 rands. And for legal aid for a civil or criminal matter, individuals who are members of a household who owns immovable property has their net immovable and movable assets increased from 640,000 to an amount of 665,800 rands. In addition, the means test as an extension of Security of Tenure Act for eviction matters is set at 13,625 rands as legislated in the extension of Security of Tenure Act. Legal Aid South Africa Land Rights Management Unit has been operational since the 5th of January 2022 and is currently managed by the Legal Aid South Africa National Office. The Legal Executive Land Rights Management is responsible for overseeing and monitoring the performance of the LRMMU, and new vacancies have been filled in line with an interim organizational structure for the unit. Most legal practitioners who were previously providing legal representation to farm occupiers, labor tenants, and restitution claimants throughout the LRMU have been aggregated with Legal Aid South Africa on the Judicare system and continue to provide legal services as required. Internal capabilities to deal with the newly created LMRU's financial and file management system have been developed by Legal Aid South Africa. This development enables Legal Aid South Africa to contribute to South Africa's land justice program and ensure access to justice, realize the right of persons to have legal representation as envisaged in the Constitution, and provide legal aid and legal advice. And this will definitely increase access to farm occupiers, farm dwellers, and labor tenants. Building institutions use enforce accountability for crime and maladministration. The National Prosecuting Authority budget allocation. The NPA has been allocated 4.9 billion rands, which is an increase of 374 million rands. In the previous financial year, we had set aside 106 million rands for the investigative directorate. This year's allocation for the NPA is increased by 137 million rands. 243 million rands and 243 million rands in this financial year. Despite the continuous performance, inhibiting challenges hampering optimal performance attributable to COVID-19 pandemic, the NPA continued to improve organizational performance compared to the previous 2 financial years. In ensuring that the NPA delivers quality prosecutions, high conviction rates were maintained in all court forums. Conviction rates of 91.1% in high courts, 80.8% in the regional courts, and 94% in the district courts were recorded in the current financial year. Some progress has been made in improving case finalization. Leveraging on the Fusion Center, the NPA has been crucial in addressing corruption related to the COVID-19 funds. A total of 232 matters have been registered with the Fusion Center. 173 matters are under investigation and 59 have been closed. The Asset Forfeiture Unit continues to play a critical role in addressing the scourge of corruption and has delivered significant returns in the last financial year. The Asset Forfeiture Unit obtained freezing order to the value of 46 billion rands, to the value of 5.6 billion rands in corruption or related offenses. At the end of the financial year, 70 million rands was paid into the criminal asset recovery amount, and 210 million rands was paid to the victims of crime. The Special Investigating Unit. This year, the SIU marks 25-year anniversary with an allocation of 152 million rands. In the last financial year, the SIU has achieved significant recoveries through combining quality investigations with civil litigation. Between 2013 and 2021, the SIU has recovered public money and asset amounting to 2.6 billion rands, set aside contracts to the value of 18 billion rands, and as of 26 March 2022, referred matters worth 75 billion rands for civil litigation in the High Court and the Special Tribunal for Civil Litigation. The establishment of the Special Tribunal in 2019 has expedited the work of the SIU. The tribunal has adjudicated cases referred to it by the SIU amounting to 8.6 billion rands in unlawful contracts. One of the cases that were finalized includes the Bedbridge Board of Fence contract worth more than 40 million rands. The tender was irregular and set aside, and contractors were ordered to pay back the money received. The SIU had enrolled 119 cases worth more than 12.8 billion rands at the Special Tribunal. Out of the 119 cases, 48 cases worth 2.2 billion rands are related to the COVID-19 procurement corruption and maladministration. President Cyril Ramaphosa has appointed Judge Lebogang Modiba as the president of the Special Tribunal and added Judges Soma Naidu and Johannes Dafu, both of the Free State Division of the High Court, as the members of the tribunal. I would like to congratulate Judge Modiba on a new appointment as the president of the tribunal and thank the former president Judge Mlindelwa Makhanya, who has retired, for the meaningful role he has played since its establishment. He led the special tribunal with distinction, and we wish him well in his retirement. Systematically addressing the roots of gender-based violence and femicide. Gender-based violence and femicide remains a pervasive challenge in South Africa. Following presidential directive, the courts continue to put special emphasis on conviction in sexual offenses cases. The high conviction rate of 74.4% for sexual offenses cases demonstrates the success of this focus. The NPA participates extensively in the implementation in terms of Pillar 3 of the National Strategic Plan as facilitated by the Department of Women. However, more needs to be done to address this scourge. The Tutuzela Care Center model aims to provide a more effective and victim-centric approach to reporting sexual offenses. During the financial year, the NPA increased the number of operational TCCs from 55 to 60. The fight against violent crime, particularly rape, has recently been undermined by the challenges around the management of forensic DNA due to shortages of essential chemicals required for DNA analysis. It resulted in a national backlog of these cases being prosecuted in courts. As part of our interventions, the NPA established a partnership with the South African Police Service Forensic Science Laboratory to reduce the backlog in DNA processing, share ideas, and deal with the backlog. The NPA is capturing these reports or priority requests for DNA from the divisions received from FSL and compiles a monthly consolidated report. The improved coordination between the NPA and the Forensic Science Laboratory has assisted in reducing the backlog extensively. GBV is entrenched by patriarchal social norms and belief systems, gender disparity, socioeconomic inequality, family dysfunctions, the low social values attached to women and girls, and the lack of accountability at all levels of responsibility. If men in particular do not take personal accountability, GBVF will continue to traumatize our society unhindered. For this reason, Article 1 and 2 of the Presidential Summit Declaration against Gender-Based Violence and Femicide of 2019 unequivocally holds every person living in South Africa accountable for actions and omissions that are contrary to the realization of a South Africa free from this kind of violence. In support of the aspirations of the Summit Declaration and the National Strategic Plan, and in particular in response to the demands of women who took to the streets in 2018 against the scourge of gender-based violence, I introduced the gender-based violence bills in August 2020, which the president recently assented to into law on the 28th January 2022. And I want to thank this House for their enduring support and the hard work, sleepless nights to ensure that these bills reach finality. The 3 Gender-Based Violence Amendment Acts do not only ground the principles of victim-centric justice system, but also inculcate the spirit of accountability by all, for all. For example, the Domestic Violence Amendment Act of 2021 criminalizes bystanders by adults in domestic violence matters perpetrated or suspected to be perpetrated against children, persons with disabilities, or older persons. Awusakwazi ukubukela. If uyazi lento kufanele uyireport. Section 54 of the Criminal Law Sexual Offenses and Related Matters Amendment Act, number 32 of 2007, criminalizes and punishes the failure to report knowledge of a sex crime against a child or persons with a mental disability. With these laws in place, we should not have any surge in cases of child abuse, statutory rape, and even child pregnancies. Vatsonga va rambo famba enkoveni lunda ri ta vonaka. You cannot hide anywhere. Everyone is my sister's keeper. We all have a responsibility to report these crimes. In continuing with our commitment to provide a victim-centric court system, in the 2022-2023 financial year, the Department of Justice and Constitutional Development will upgrade additional disability-centric courts above the 75 courts introduced in the previous financial year. With these courts, the department is progressively building a court system that observes that reasonable accommodation for court users with disability to ensure the equal enjoyment of the right to equal protection and benefit of the law and fundamental freedoms by all. This support is also extended to older persons. One of the 3 GBV laws, the Criminal and Related Matters Amendment Act number 12 of 2021, extend the provision of intermediary services to older witnesses and civil proceedings. The Domestic Violence Amendment Act number 14 of 2021 further permits the use of online application for protection orders. This is a viable option for victims of domestic violence to access our court services remotely and in convenient and safe environment of their choice. The department has already developed the online web portal for domestic violence application for protection orders. And this system will be accessed by the public as soon as the date of commencement of this act is set this year. Very soon, I shall be approving the amendment to the regulation to the Domestic Violence Amendment Act. Shortly, I shall also be approving the amendment to regulations for the National Register for Sex Offenders, which has been aligned with the new criminal law, Sexual Offenses and Related Matters Amendment Act number 13 of 2021. In response to the call made by women of South Africa in 2018, this Amendment Act requires the particulars of all convicted sex offenders to be entered into the National Register for Sex Offenders, irrespective of the age and the mental status of the victim. No registered sex offender will be allowed to work or operate a business in an environment accessible to vulnerable persons, defined as children, female students, or lecturers under the age of 25 years, persons living in shelters, and certain categories of persons with disabilities and older persons, and so on. In facilitating the implementation of this act, the Department of Justice and Constitutional Development has developed the online web portal and the SMS notification system for the National Register on Sexual Offences Services, which will be made accessible to the NRSO applicants in this financial year. The decentralization of certain services of the NRSO to our lower courts will also commence during the same period. Through the implementation of the NRSO, the department intends to curb the exposure of vulnerable persons to pedophiles and serial sex offenders, and also to prevent sex offending in the country. It adds more pain to victims of gender-based violence when their perpetrators roam the streets shortly after police arrest. In terms of the Criminal and Related Matters Amendment Act number 12 of 2021, bail in GBVF matters must be denied unless it will be in the interest of justice to grant such a bail. This Amendment Act also brings to an end the granting of what is referred to as the police bail or prosecution bail in GBVF matters. All applications for bail in these cases must therefore be made in a court of law. Modernizing the justice services through the use of digital capabilities requires a supporting, responsive, and stable underlying IT infrastructure. The department's currently aging IT infrastructure does not bode well in this regard. The department endeavors on upgrading and ensuring the continuous upkeep of its IT infrastructure, as this will not only impact the delivery of existing services enabled by technology, but also its modernization program. In the last financial year, the department piloted 4 online justice service projects. Maintenance online services were piloted at the Family Court in Durban Point. The Trust Online Services solution enables the online registration and submission of documents in respect of the new trust applications. This solution was piloted at the Master's Office Pretoria.
Thank you,
with identified
Honorable
trust agents.
Minister. My face has been there for over a minute.
Oh, okay.
That's a warning when it comes, it appears. That's a warning to say you are left with a minute. So unfortunately, your time is now expired.
Okay, no, thank you, House Chairperson.
Thank you, Honorable Minister. We now proceed, honorable members, and call on the chairperson of this portfolio committee, Justice and Constitutional Development, Honorable Makwanishe.
Thank you very much, Honorable Chairperson, Honorable Minister Ronald Ozila Mula, Honorable Deputy Minister John Jeffrey, Honorable Deputy Minister Nkosi Phathekile Holomisa, Ministers and Deputy Ministers present, the Director General of the Department of Justice and Constitutional Development, Advocate Mashabane, honorable members and distinguished guests. We would like to take this opportunity to pay a special tribute to sons and daughters who held their last breath whilst in the service of the Justice family during the year under review. Our nation shall forever be indebted to you and your family for your sacrifices and commitment. We also welcome those who were able to survive COVID-19 and other illnesses and came back to work. Honorable Chairperson, we are a nation in mourning for our fellow compatriots who lost their lives in recent floods in KwaZulu-Natal and the Eastern Cape. Others lost their belongings to fires in the Western Cape. May the Almighty be with their families and friends during these trying times. Honorable Chairperson, the leaders and managers in the public service of today do not have the luxury of resources of yesteryear. The impatience of our people for quality service delivery is palpable. The challenges of today require different skill sets from both managers and leaders. They require innovation and entrepreneurship, not how best to manage resources in front of you, but how to innovate around little resources around you. As we look at the issue relating to the past, we also need to feel the pulse of frustration that our people experience on a daily basis. Chairperson, we were dissatisfied by certain aspects of the Justice Department plan. We therefore welcome a letter from the Minister informing us that the department has listened and would revise its plan accordingly. We are pleased that the Chief Financial Officer, Ms. Irene Singo, has been appointed from the 1st of April 2022. We note that the department intends to implement its turnaround plan this year and will monitor progress thereof. We believe that greater attention should be given to maintaining infrastructure, which is in a terrible state. We welcome the department's intention to explore the use of entities to implement projects for improved delivery. There are also discussions with the Department of Public Works and Infrastructure to increase the delegations for day-to-day maintenance so that the department can undertake more of its own maintenance. We remain concerned by the growing number of case backlogs. We believe that additional resources are needed to prevent these from overwhelming our legal system. We will continue to monitor the backlogs in respect of GBV cases. We have asked for further details about the strategy to transform the Master's Office. We urge the department to finalize the position of the Solicitor General so that the recruitment process can begin. We note that following the ransomware attack last September, the department must rebuild its ICT infrastructure from scratch. We know the department's plan to implement various online solutions in 2022-2023, but we are concerned about the connectivity challenges on the ground. The committee also notes the intention to roll out 59 IJS-related projects in 2022-2023. We welcome the NPA's intention to focus this year on pursuing high-profile corruption matters. 9 seminal corruption matters are prioritized for enrollment within the next 6 months. The NPA is allocated an additional 1.1 billion rands over the medium term. A significant portion is allocated to the Investigative Directorate so that it can employ 90 extra permanent staff members with specialist skills and experience, and also develop existing employees. The NPA is also able to recruit 17 senior state advocates for the Asset Forfeiture Unit and 12 protectors for the Office of Witness Protection, as well as employ 700 aspirant prosecutors in the National Prosecuting Service. We congratulate Advocate Andre Johnson on her appointment as head of the Investigative Directorate, and note that the leadership transition has been described as seamless. Budget cuts have required Legal Aid South Africa to reduce posts, contributing to the increased number of case backlogs in the criminal courts. Also, fewer clients can be assisted in civil matters with advice. We note that Legal Aid South Africa is allocated additional funds to employ practitioners for the new specialized commercial crimes courts that have been set up in 6 provinces. We welcome the transfer of the legal representation function in the land matters from the Department of Agriculture, Land Reform, and Rural Development to Legal Aid South Africa. We agree that the SIU funding model must be addressed. We urge the department to finalize legislative amendments that will address the establishment of a permanent SIU, deal with funding concerns of the SIU, and monitoring and enforcement of remedial actions. Additional funds have allowed the Public Protector South Africa to provide for ICT infrastructure, e-library, 22 staff posts, and an electronic document management system. We note that the South African Human Rights Commission's investigation into the cause of the July 2021 riots is near completion. The Commission will also monitor the provision of alternative housing, food, water, and healthcare relating to flooding in KwaZulu-Natal. We congratulate Advocate Penty Hlakula, Advocate Lebogang Cordelia Strom Nzama, Advocate Johannes Colin Wipont, and Mr. Mfana Gwala on their appointment as members of the Information Regulator from the 1st of December 2021. We ask the Minister to urgently intervene in the matter of the regulator's listing under PFMA. The committee, having considered the budget vote number 25, Justice and Constitutional Development, support it and recommend that it be approved. Thank you very much, Chairperson.
Thank you very much, Honorable Magwanishe. From the DA, we will call on the Honorable Advocate Breitenbach.
Thank you, Honorable House Chair, and good afternoon. House Chair and honorable members, the Department of Justice and Constitutional Development has declared the year 2022-2023 a year of the community. This will reportedly culminate in the rollout of an extensive community outreach program to interact with communities about justice services and issues of constitutionalism, promotion of human rights, and respect for the rule of law. For the 2022-2023 financial year and over the medium term, the Justice Department's projected performance and expenditure is shaped by a focus on increasing access to its services and strengthening the fight against maladministration and corruption. These are lofty ideals. Indeed, they are laudable ideals, and ideals that we naturally support. Putting South Africans first, lowering the crime rate, and deploying many corrupt cadres to jail sounds wonderful. But then, honorable members, there's a huge gap between having wonderful plans on paper and actually implementing them. The Portfolio Committee has been engaging with the department for some years now on various challenges, including the decline in the department's performance, accompanied by qualified audit opinions in respect of the voter count and predetermined objectives over the past 5 financial years. The position is so bad that the committee has recommended the involvement of the Public Service Commission to investigate the root causes of the challenges and identify possible solutions. The increase in court backlogs in both the district and the regional courts, described by the department as insurmountable for the past 2 years, remains a serious challenge, and no progress is noticeable in this regard. Court hours continue to dwindle, and unless much needed discipline is imposed, the backlog will simply continue to spiral uncontrollably. Cases are increasing and will increase exponentially when the matters emanating from the Zondo Commission are trial ready. Our courts are simply not going to be able to deal with the massive amount of work generated. One cannot lose sight of the fact that the backlog is ever increasing with just the ordinary criminal matters being generated, and that these cases cannot be shifted aside to accommodate the massive scale corruption, fraud, theft, and money laundering prosecutions that must follow on Zondo. There simply is no possibility of the police, the NPA, including the ID, which has a limited lifespan and must end in less than 2 years, and the courts dealing with it all. The run-of-the-mill cases must be dealt with expeditiously. Those are the cases that carry the interests of ordinary citizens and cannot be left aside to deal with state capture. The only possible way out of this is to form a new Chapter 9 institution along the lines of the Anti-Corruption Commission, and given the autonomy, security of tenure, budget, and capacity to properly investigate and prosecute these matters generated by the Zondo Commission and state capture. The growing inefficiency of our court system is exacerbated by internal failures of the department, such as failure to ensure effective contract management, which has resulted in the breakdown of court recording systems for which the contract expired some time ago with nothing in its place, and the failure of CCTV systems countrywide. Of course, the total failure of the Department of Public Works to carry out any discernible maintenance of any court buildings must get an honourable mention. The ransomware attack in September 2021 impacted negatively on service delivery. We still do not know why there was insufficient protection against such an attack, nor do we know precisely what information was compromised nor what became of it. The information regulator has indicated that the department was less than ideally cooperative in this regard, and one must wonder why. The service delivery of the department is left wanting on so many levels. We are constantly inundated with complaints and requests for assistance with services or lack thereof from the master's offices countrywide, and oversight visits made it very clear just how shocking the service delivery is. Long queues form from the early hours in the morning. Elderly people and pregnant women are forced to stand on pavements for hours, often repeatedly, before they are fortunate enough to be attended to. The systems are down more days than they work, and the offices are closed to the public from 1 o'clock daily. It's simply untenable that citizens are treated in this fashion. While the oversight visits also revealed some very pleasant surprises of outstanding service delivery, these were very limited and isolated. Generally speaking, the visits revealed crumbling infrastructure, total lack of maintenance, poor accommodation, and a sad lack of the tools of trade, poor or no stakeholder management, and shockingly inadequate contract management. Court staff and officials are literally left to their own devices, with no functioning landlines, no internet access, no or very limited access to proper libraries and law reports, and inadequate support staff. The department is, quite frankly, a rather depressing mess. This decline is hardly surprising, however, when one takes into account that the minister thought it was more important for him to attend an ANC event in East London rather than be present at the committee on the 6th of May for the presentation of the budget and annual performance plan. His attention is clearly elsewhere. Much is made of the newly enacted swathe of gender-based violence legislation. Our committee worked very hard to ensure that this very important legislation was finalised and passed in good time, often sitting late into the night. Having done so, no one should assume that legislation, even good legislation, is the answer to the ever-increasing scourge of gender-based violence. Clearly, a strong and positive approach by the criminal justice system must act to discourage and deter. But then we are confronted with the type of occurrences that took place in the past few weeks. The murder trial of Mongani Ngadleka, accused of stabbing to death Pelakazi in Catania, was delayed once again in Khayelitsha because the court ran out of photocopying paper and could not supply a copy of the docket. In Wolseley, an accused and an illegal immigrant in an attempted murder trial, allegedly for stabbing a guest house owner 10 times, was released on warning after the state had opposed bail. Needless to say, he did not appear on the next date, but did subsequently allegedly kidnap and rape a minor and is now in hospital after the community exacted their own revenge. So, honourable members, while the Minister gallivants, the Justice Department is in a serious state of decline, and the criminal justice system is in serious trouble. The Master's office is a shambles, the State Attorney is in no better state. Consequence management is a pipe dream, and there is no evidence that contract management has received any attention, despite a litany of disasters. It will require serious and constant attention and a firm hand on the tiller to set it on the path to recovery. Given the Minister's current preoccupation with party business, there can be no guarantee that this will be achieved. I thank you.
Thank you, Honorable Member. We now proceed and invite the EFF and recognize Honorable Yaku.
Thank you very much, Chairperson. Chairperson, the EFF rejects Budget Vote 25 on justice and correctional and constitutional development. South Africa's democracy is entering a very dangerous period during which the very concept of justice and the rule of law will be severely challenged and undermined. We are already seeing glimpses of a justice system that is employed by the rich and the powerful to advance their interests while silencing the poor and the vulnerable. This phenomenon is more pronounced under the Ramaphosa regime than it has ever been since 1994. Take, for instance, the factional prosecutions by an equally factional and redundant National Director of Public Prosecutions. In May last year, the Hawks sent a file to the NPA in relation to fraud and corruption in the manner of the Eastern Cape and how its government handled the funeral arrangements of the late Mama Winnie Madikizela Mandela. The Hawks completed their investigation and recommended that the NPA must charge Mabuyane. To this day, the NPA has not charged Mabuyane because he is a key member of those supporting Mr. Ramaphosa. That is not the end of it all. Take, for example, Steinhoff, which represents the biggest corporate fraud in the history of this country. The Public Investment Corporation lost over 21 billion rands from that corporate heist. This is the direct public money looted by white corporate criminals. Despite having taken more than 200 witness statements from those involved with this corporate heist, the NPA has no appetite of any kind to pursue the criminals involved. The whites involved in looting Steinhoff are enjoying their holidays unbothered, while the NPA is busy fiddling fingers, getting involved in politics. The worst policy development regarding the NPA are the recent moves by the leadership of the NPA and the Minister of Justice to source private funding for the NPA. When this happens, it will practically hand over the constitutionally enshrined functions of the NPA to private individuals and make the prosecutions agency dance to the whims of those who fund it. Our public prosecutions will lose whatever semblance of independence that they have left and will never have the goal to prosecute wrongdoing by those who fund it. This is a poorly thought out plan by the minister and is treasonous in fact. But the treason is not something new in a way you function as a minister. Your conduct relating to the appointment of the acting judges in the Constitutional Court must be seen in the context of the ongoing plans by this administration to capture almost all branches of the justice system in this country. Going as far as wanting to remove names proposed by the then acting Chief Justice with names you prefer for acting justices is a step too far. But with the media and your side, you may think that these will not come back to haunt you. But these erosions of the independence of the judiciary will come back to haunt you, Minister, and the rest of the country. We condemn your lack of support for the Office of the Public Protector and your complicity in the mainstream media assault and undermining of that office. Advocate Busisiwe Mkhwebane, despite some of the mistakes she has made, does not deserve to be treated in the way by a democratic government. The fact that the matter is that she has released hundreds of reports that have not been found to be wanting, protecting the rights of thousands of South Africans. She is subjected to impeachment today because she dared to release reports that challenge the sainthood of Mr. Ramaphosa and Jamnadas. We'll defend the public protector and the integrity of the office she occupies by all means necessary. We want a criminal justice system that is able to investigate and prosecute criminals without fear or favor. We want a public protector who is not hounded.
Chairperson.
We want.
I see your hand, Honorable Khadebe. Yes.
No, thank you, Chair.
Are you rising on?
Chairperson, I'm rising on Rule 82. The member knows very well that we cannot refer each other on first name terms. She just referred to the Minister of Public Enterprise in the first name terms. Thank you, Chair.
Thank you very much, Honorable Yako, I heard you very well. You referred to the
Mr.
president,
Jamnanda.
and when you, no, but that's not what you said, but you haven't listened to me. Please, let's follow the rules. Rule 82 expect that from us. Thank you.
Fine.
Proceed.
Mr. Jamnanda then. Thank you. We will defend the public protector and the integrity of the office she occupies by all means necessary. We want a criminal justice system that is able to investigate and prosecute criminals without fear or favor. We want a public protector who is not hounded like a wild animal merely because she dared investigate and be investigated by the powerful. We want a human rights commission that is deeply rooted in the idea of justice, particularly for the dispossessed majority. We want our courts to be left independent to interpret the law without undue influence by the rich and the powerful. So therefore, we reject this report. Thank you.
Thank you, Honorable Member. We now proceed and invite the IFP and recognize Honorable Musina.
Thank you, Honorable House Chair. The access to justice for the ordinary man on the street is not a lofty ideal. At its core, it relates to efficient, cost-effective means to resolve disputes. It relates to capable and competent institutions serving the public, such as the Master's Office and the Deeds Office. Grand promises of modernizing and increasing access to justice, as the department envisions in its annual performance plans, means very little in face of the reality of the state of the extensive backlog experienced by our criminal courts, aging infrastructure, and the dire state of the Office of the Master of the High Court. At the end of March 2021, only 41% of the criminal case backlog, representing cases older than 12 months in the High Court, was reduced, according to the latest Judiciary Annual Report. This reality causes a massive delay in justice, and we cannot continue to use the pandemic as an excuse. We need to interrogate the reasons for these delays, as justice delayed is justice denied. The Master's Office, which experienced a serious blow due to cyber attacks last year, forms a critical function to the public, including administrating deceased estates and administrating the Guardian's Fund. Any delay in its operations has a dire effect on the public. The situation prompted the Portfolio Committee to demand action and report backs from the department on the situation. However, despite clear deadlines provided, the department failed miserably to provide the committee with such reports. This omission cannot and should not be simply tolerated. As a Portfolio Committee, we are denied the means to effectively fulfill our constitutional oversight duty. The IFP strongly endorses the Portfolio Committee's sentiment that this failure also denied the committee to properly consider and interrogate the department's budget. Finally, in light of the massive task the National Prosecuting Authority faces in prosecuting state capture cases, the IFP welcomes the much needed increase in its budget. However, the stark reality is that, considering the scale of corruption laid bare in the Zondo Commission's reports, much more funding will be needed over the next 2 years to ensure the authority has any chance in prosecuting these complex cases. The IFP will furthermore closely monitor the progress of the investigative directorate's prosecution of the 9 corruption cases relating to state captures, which the directorate has set out to complete over the next 6 months. These cases will serve an important measurement of the directorate's ability to prosecute such cases, and the outcome thereof will be critical to restore the public faith in the NPA. May this year mark the year that we as a country honestly see justice being served and those implicated in state capture finally be prosecuted. The IFP accepts the budget vote, and I thank you, Honorable House Chair.
Thank you, Professor. As we proceed and now invite the FF Plus and recognize Honorable Mulder.
Thank you, Honorable House Chair. Honorable Chair, the committee report before the House today is a reflection if South African government is able to uphold and protect the Constitution and the rule of law. The reduced salaries budget will affect overall effectiveness on the legal system, which relies heavily on warm bodies to deliver a wide range of services. The Freedom Front Plus therefore welcomes the reprioritization of the 2022 budget by the Minister of Finance to allocate more funds to the National Prosecution Authority, while additional funding should be made available to the Special Investigating Unit as well. Honorable Chair, the State Capture Commission should be allowed to complete its work in the fight against corruption, and enough capacity ensured for the investigation and prosecution of criminal cases emanating from the Capture Commission. The further reprioritized budget of 426 million rand over the medium term is therefore welcomed. The Freedom Front Plus is, however, concerned about the significant decline in the number of convictions against government officials in recent years. For the 2021 financial year, the relevant conviction figures more than half from where they were in 2016-17. The evidence simply does not support claims of a particular focus on corruption. The National Prosecuting Authority was indeed one of the hardest hit by the Zuma years, and the effects are still being felt by the large numbers of vacancies at the NPA, the dearth of highly skilled and experienced prosecutors, as well as staff morale issues. Honorable Chair, it seems as if the National Prosecuting Authority is pursuing easy win cases across all forms of crime at the expense of more complex prosecutions that could bring down its misleadingly high conviction rate. Chair, the mere fact that the State Departments owe the Special Investigating Unit more than 650 million rand could pose a serious threat to the crucial important institution. Without a well-funded and equipped Special Investigating Unit, a more effective National Prosecuting Authority, and the completion of the work of the State Capture Commission, the government will not be able to uphold and sustain the Constitution and the rule of law. Chair, therefore, the Freedom Front Plus will not support this vote. Thank you.
Thank you, Honorable Mulder. We now recognize Honorable Swart from the SACDP.
Thank you, House Chair. House Chair, it is the central role of the state to protect its citizens and uphold the rule of law. Now, the ACDP believes that it is largely failing in this regard, despite the best efforts of thousands of dedicated judges, magistrates, court officials, and prosecutors. The criminal justice sector is struggling to cope with the high levels of crime and violence, and the average law-abiding citizen feels overwhelmed by the lawlessness pervading the nation. Consider the high levels of gender-based violence, senseless murders, robberies, hijackings, and kidnappings. One can add ongoing taxi and trucker wars, the construction mafia, corrupt tenders running to billions of rands, the coal, and diesel syndicates, the copper mafia, illegal mining, state capture and the looting of SOEs, theft of rail infrastructure, bribery and kickbacks, political assassinations, and corrupt municipalities. The list is almost endless. The ACDP has called for more resources to be made available for law enforcement and the NPA to respond to this lawlessness. This in the knowledge that the most effective deterrent to crime is the sure knowledge that a perpetrator will be arrested, successfully prosecuted, and sentenced to a lengthy period of imprisonment. Sadly, there appears to be very little deterrent to crime in the country, and South Africans are understandably demanding that more must be done to ensure that criminals are placed behind bars and stolen state funds recovered. And the ACDP agrees. The NDPP recently estimated that 1.5 trillion has been lost to corruption. Just think what could be done with this additional funds to stimulate the economy, create jobs, and assist the poorest of the poor. We commend the work done by the SOU as well as the NPA, including the Investigative Directorate and Asset Forfeiture Unit. The successful preservation order for the Gupta-owned Optimum mine of 3 billion rand is welcome, and we look forward to the next 6 months, which Advocate Patohi said would be, quote, seminal in the prosecution of state capture and corruption cases. The committee's recent visits to courts and buildings in several provinces revealed the deplorable, shocking state of courts. Not only are some of them so neglected that they are structurally unsafe, court cases cannot be held in these buildings, and this cannot be allowed to continue. The ACDP has also expressed its concerns about the arrests arising from the COVID-19 regulations, where many citizens were unaware that paying an admission of guilt fine resulted in them having a criminal record. We do believe that it is desirable not to make criminals of citizens for these minor offences, and we are pleased that the department will look at the Judicial Matters Amendment Bill later this year. I thank you, House Chair.
Thank you, Honorable Swart. Thank you very much. We now invite the Deputy Minister of Justice and Correctional Services responsible for justice and correctional development, the Honorable Jeffrey.
Thank you, House Chair. It's constitutional development, not correctional development, but Honorable Chair, Honorable Minister Ronald Lamula, Deputy Minister of Correctional Services, and Nkosi Patikile Holomisa, members of the Executive, Chairperson and members of the Portfolio Committee on Justice, honorable members, Director General, Advocate Mashabane, and officials of the Department of Justice and Constitutional Development. When we were in Delft on the Cape Flats last Friday at a justice service in Bizo as part of the Year of the Community program, we were once again reminded of the vital importance of government being visible and active within our communities. The best way to know what communities are experiencing and what they require is to hear it directly from them. In the same way that Parliament conducts oversight work, government departments should monitor the situation within our communities. Where things are not working, we need to know and we need to address it without delay. It was for this reason that I conducted 2 unannounced visits to the Master's offices earlier this year, together with the Chair and Deputy Chair of the Legal Practice Council. I wanted to establish firsthand how well these offices were functioning, whether practitioners and the public were being served timeously and professionally, whether existing backlogs have decreased, and whether there have been improvements in the terms of the issuing of letters of executorship and letters of authority. It is common knowledge that complaints and concerns have been directed to the department regarding service delivery issues at various Master's offices. The Master's offices are responsible for the administration of liquidations and deceased estates, the registration of trusts, and the administration of the Guardians Fund. This often means serving the most vulnerable members of our communities, such as the widowed families who have lost loved ones, and children and the elderly in particular. These unannounced visits are part of our efforts to constantly keep monitoring service delivery at these offices, and I will continue with unannounced visits at various masters' offices until we see a very clear improvement in service delivery. The masters' offices are currently, together with the Information System Management, ISM, working on an online registration of deceased estates, as well as online registration of trust system. The development and rollout of online registrations will show a convenient method that allows people who want to report deceased estates or register trusts to do so remotely from their homes, offices, or any other place. The approach will effectively reduce the number of customers having to travel to the offices of the master or the various service points, and will enhance access to the master's services in the country. Online registration will also speed up the registration process and ensure quicker availability of the particulars of beneficiaries and trustees. However, I cannot say that I'm at all satisfied with the performance of the master's offices and expect that a lot more will be done and improved, in particular with regard to file management and responding to queries from clients. The process to revisit and amend the Administration of Estates Act of 1965 in its totality, so as to allow for modernization and for keeping up with electronic developments in the country, has already started in the past financial year. Similarly, the process to amend the Trust Property Control Act of 1988 to allow for modernization also commenced in the last financial year. This will allow the master to obtain and keep more of the information needed to curb fraud and money laundering. In addition to the master's office, another area of serious concern to me is the functioning of our magistrates' courts. Infrastructure and maintenance are ongoing challenges, and the Minister and I have met with the Minister and Deputy Minister of Public Works and Infrastructure in this regard. As I mentioned in the OCJ budget vote debate last week, court performance and efficiency are to a large degree within the purview of the judiciary, but there are many areas of responsibility which are that of the department and where our performance can and should be improved. The issue of faulty court recording technology, or CRT machines, and sexual offences systems, or SOS, is one which I've raised with the department on numerous occasions and an issue which I'm monitoring closely. During the last quarter of the previous financial year, the department experienced major setbacks within the IT space. Contract positions of IT personnel and service providers came to an end at almost the same time, and this left our systems vulnerable. As a result of that, our court recording systems and sexual offences systems were affected, and this forced courts to postpone cases. The problem was not that the procurement was started late, but that there were problems in the procurement process itself, which then caused considerable delays in terms of having to be redone. However, since early February, a service provider has been appointed and is attending to repairs and maintenance of the court recording technology and SOS, or sexual offences systems, in our courts. Parallel to this process, the procurement process for a long-term solution is underway. The accounting officer is also conducting an investigation and will take appropriate disciplinary steps where necessary. With regard to case backlogs, and specifically those aspects which form part of our department's responsibility, the department has developed an action plan to be implemented immediately to address those challenges impacting on court efficiency which fall within the department's mandate. During the current year, the department will work with all the JCPS cluster departments to enter into a memorandum of understanding that will see each department crafting a performance indicator in their own annual performance plans, which will contribute towards reducing the case backlogs. Our action plan includes interventions such as overtime work, backlog courts being established where feasible, regular meetings with service providers, for example, the CRT service providers, the provision of additional human resources, psychosocial support for court officials to improve on the rate of absenteeism, regular repair and maintenance meetings where the regional heads and the ISM meet with service providers every Wednesday to track progress, the procurement of additional IT equipment and facilities interventions, such as procurement of portable battery packs and generators, facilitation of the carrying out of minor maintenance works, and the procurement of mobile units to be used as courtrooms and testifying rooms. The current initiatives being developed still have to be discussed with the lower court judiciary, and consultation with the respective judicial forums will be taking place soon. There is a need to establish a platform for an interface between existing judicial reporting structures, both national and provincial, to engage in ongoing consultations and feedback to ensure meaningful interactions and to ensure the required support from the department. Magistrates' courts are at the very coalface of our justice system, and it is vital that these courts, which are often the first port of call for the dispensing of justice, are well capacitated and functioning optimally. The Minister made 158 new magistrates appointments in vacancies around the country. These magistrates assumed their duties in October last year, and the filling of these vacancies is an important step in capacitating our judicial officers and our courts so as to enable them to deliver justice to all. Chairperson, our department has begun on the process of consolidating and rationalizing the provincial offices to act as one department and not several independent units. Corporate services will be offered under one roof to the masters, the family advocates, the state attorney, instead of sourcing the same from the national office, as this is expensive and delays the provision of services. Furthermore, in line with the President's vision of bringing government services closer to the people and cutting down on wastage and duplication, our department plays an active part in the district development model. Honourable members, our small claims courts improve access to justice and make civil justice inexpensive, less formal, and accessible to those who cannot afford litigation in the ordinary courts. These courts are used to settle minor civil disputes and claims of up to 20,000 Rand between the parties without representation by an attorney in an informal manner. In 1994, at the dawn of our democracy, these courts were still mostly in white and urban areas. Today, we have 415 small claims courts countrywide. With the additional 49 places of sitting, that means there are 464 places where small claims court sittings can be held. We currently have 2,009 commissioners. Of these, 239 are legal aid SA practitioners, and 98 are magistrates who also sit as commissioners after hours and at no extra remuneration. We want to thank all the small claims court commissioners, many of whom are private legal practitioners, for the service that they provide free of charge to the community and to ensure access to justice for all. We are pleased that to advise that the Rules Board has made new rules for the small claims courts. The new rules aim to address areas where the current rules are deficient and will greatly assist litigants in the small claims court. Upon the gazetting of the new rules, they will be tabled in Parliament. Chairperson, as the world celebrates the International Day Against Homophobia, Transphobia and Biphobia, or IDAHOT as we know it, I want to add the voice and support of government in acknowledging this important day, and that is today. The date of 17th of May was specifically chosen to commemorate the World Health Organization's decision in 1990 to declassify homosexuality as a mental disorder. IDAHOT was created to draw the world's attention to the violence and discrimination experienced by lesbian, gay, bisexual, transgender, intersex people, and all other people with diverse sexual orientations, gender identities, or expressions and sex characteristics. We're pleased with the work of our National Task Team on the protection of the rights of LGBTIQ persons, and with its Rapid Response Team, which is monitoring and tracking hate crimes against LGBTIQ persons in the criminal justice system. The National Intervention Strategy provides the framework that informs the functioning of the NTT to counter violence and discrimination that is grounded on sexual orientation, gender identity and expression, and sex characteristics in South Africa. We've recently reviewed the NIS and expanded the scope of human rights violations to be monitored and addressed beyond those of hate crimes only, but also to include discrimination and hate speech. I also want to congratulate Gender Dynamics and Iranti on their successful bid to host ILGA World in Cape Town in 2024. At the end of last year, we hosted a very successful international policy dialogue on the rights of transgender and intersex persons, and we look forward to building on the success of that event. Honourable members, the decriminalisation of sex work is specifically mentioned in the National Strategic Plan on Gender-Based Violence and Femicide. In Pillar 3 of the NSP, there are a number of key interventions, key activities and indicators. One of the key activities is, and I quote, finalisation of legislative processes to decriminalise sex work, fast tracking and promulgation. Currently, the selling and buying of sexual services are criminalized in our country. There are various different policy options to consider with a view to legislative reform, and I've been engaging with key stakeholders on the form that this reform should take. We hope to take a bill to Cabinet soon, which will be published for public comment before returning to Cabinet for approval and introduction to Parliament. The issue of decriminalization may be a difficult and a contested one, but it's also one that needs to be debated and a decision taken, as the issue has been one that has been delayed for far too long. Finally, Chairperson, we've recently concluded a tripartite memorandum of understanding between our department, the Department of Basic Education, and the South African Human Rights Commission regarding the National Schools Moot Court competition. The MOU signing ceremony will take place tomorrow. The first annual National Schools Moot Court competition took place in 2011. It's turned out to be a groundbreaking event, and we can look back with pride over the past 11 years when we acknowledge the success of this competition in constitutional awareness and human rights education. Chairperson, these are but some of the many programs, interventions, and initiatives undertaken by our department to make access to justice and the attainment of human rights a reality for all. As we take these programs to our communities, I want to thank the Portfolio Committee for its invaluable feedback and recommendations in assisting us to better the lives of people and the justice system as a whole. And Chair, in just the few minutes that I've got, I just want to respond to the Honourable Yako, who seems to be making a habit of making wide-ranging allegations and issues. I don't know if she gets marks for that in the EFF. I can't respond. I don't have time to respond to all the issues that she raised, but just on the issue of the minister's role and the allegations against the minister regarding the appointment of acting constitutional court judges. Can the Honourable Yako please read section 175(1) of the Constitution about the appointment of acting constitutional court judges, where it says, and I quote, "The appointment must be made on the recommendation of the cabinet member responsible for the administration of justice, for the uninformed, that is our Minister of Justice, with the concurrence of the Chief Justice." So, Honourable Yako, you make lots of complaints and claims, but it doesn't help the debate and people's understanding of the justice system. I thank you, Chairperson.
Thank you, the Deputy Minister of Justice and Correctional Service, responsible for justice and constitutional development. Thank you very much. As I call on the Honorable Harold, I will hand over to my co-chair, Honorable Danji.
Thank you, House Chair. Should I start?
Honorable Harold.
Thank you, House Chair.
Yes.
So I may start. House
Yes,
Chair,
Chair.
one of the greatest challenges currently facing South Africans is the minority of politicians and crooks who feel nothing while they continue to exploit, cheat, and deny the justice system of this country, of a prosecution and of accountability. State capture and the cleaning up of corruption is of utmost importance to the survival of our democracy in our country and for our democracy to retain the faith of our people. The National Prosecuting Authority recently announced, following the damning report to the Zondo Commission, that there will be a creation of a new task force focused on state capture. This is a step in the right direction. However, the single step is at the base of the mountain of corruption that South Africans have been struggling against. If there's one takeaway from the Zondo Commission findings, it is that whatever information has been revealed is probably but a fraction of the truth. And for this country to move forward, we need to be looking not at the roots of the tree, but at rather those who are actively trying to chop it down. Advocate Shamila Batoye has admitted that this is a major challenge for the National Prosecuting Authority and that there's the likelihood of an economic collapse should the latest anti-corruption methods fail once again. We mustn't allow the words economic collapse to become so acclimatized to them that we do not identify the crisis and the impact of this on our country. We, the people of South Africa, must hold this new National Prosecuting Authority force to the highest standards possible and see to it that it remains impartial, unbiased, and independent from outside influence from its inception. We should also heed Chief Justice Zondo's advice and ensure an independent and anti-corruption agency, including a council, inspectorate, litigation unit, tribunal, and court, is established. Common sense must prevail, House Chairperson, and with more independent organizations created to protect South Africans, it would be harder for them to become infiltrated by agents of corruption. It is time for the justice system of this country to be seen to be pursuing justice and to rescue itself from our darkest hours. For this, the National Prosecuting Authority must be properly resourced. Chairperson, we must put our faith in South Africans and their cry for justice, and they will put their faith back in us. I thank you.
Thank you, Honorable Brad Heron. I now, as I come in, invited the African National Congress, Honorable Ramulu Bey, to take the platform.
Thank you so much, House Chair. Minister Ronald Lamula, Deputy Minister John Jeffrey, and Deputy Minister Holomisa, members of the executive and the legislature present, Honorable Chair of the Portfolio Committee, members of Parliament, compatriots, comrades, and friends on various platforms present here. Good day. The preamble of the Constitution clearly articulates that its adoption is to heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights. As we celebrate the 25th anniversary of the final Constitution and Bill of Rights, it is important to remind ourselves that the struggle for liberation was for the restoration of human dignity. It was for justice, freedom, and equality. The African National, House Chair, the African National Congress 1943 conference endorsed the Bill of Rights. From that moment became an official policy informing the ANC's vision for a new South Africa. The drafters of our constitution did not draft from a position of ignorance. They were guided by the African Claims document of 1943, a document which weathered the storms of colonialism and apartheid and still finds expression in the final constitution. Unlike in the present day constitutional democracy, courts during apartheid did not have the power of judicial review by which they could determine the legality of acts of parliament. Instead, courts were confined to interpreting legislation. The Bill of Rights would be meaningless if our courts could not enforce it. One of the landmark cases decided by the Constitutional Court is that of S versus Baloyi. In this case, the court held that the state had a constitutional duty to provide effective remedies against domestic violence. Penning down the judgment, Justice Sesh indicated that, read with Section 2, Subsection 2, Section 7, Subsection 2 of the Constitution, which obliges the state to protect, respect, promote, and fulfill the rights in the Bill of Rights. Section 12, Subsection 1 of the Constitution obliges the state to protect everyone's rights to be free from the private or domestic violence, the right to bodily and psychological integrity, the right to dignity, the right not to be tortured in any way, and the right not to be treated or punished in a cruel, inhuman, or derogatory way also obliges the state to deal with domestic violence. Our courts, House Chair, remain critical for enforcing and defending of rights of our people and dispensing justice. They have played a pivotal part in protecting the rights of women. The courts have consistently highlighted that women are a vulnerable group whose well-being and safety is precarious in our patriarchal society. This arises from factors linked to historical oppression, exclusion from economic activities, including economic growth. Our courts have developed rich jurisprudence which offers a gender-sensitive and social political approaches to cases. The backbone of the fight against gender-based violence are the sexual offences courts and Tutuzela care centers, which were introduced to focus on the speedy adjudication of cases involving crimes and sexual offences in specialized courts, which are equipped to deal with this unique yet heinous crimes. The responsibility of ensuring that those responsible for committing gender-based crimes are brought to account rests on the entire criminal justice system. Courts are the final arbiters in matters involving gender-based violence. They have the power to protect abused women and children and to effectively punish the offenders. And in so doing, sends a clear message to perpetrators that such conduct will not be condoned. Access to courts is therefore very paramount. While strides have been made to curb gender-based violence and violence in general, women, children, and other vulnerable groups still do not feel safe in our societies. The crime statistics are very frightening. Courts alone cannot alleviate, let alone eliminate the scourge that society faces. The concerted efforts of all South Africans, government, private sector, faith-based organization, traditional leaders, and the community at large is needed in this fight. Chairperson, the ANC government remains committed in the fight against crime and corruption. We welcome the efforts made by the Department of Justice and the entire JCPS cluster in the fight against fraud and corruption. It was reported that a total of 36 million in the financial year of 2022-2023 to invest in ICT in institutions that include the Investigating Directorate, Public Protector South Africa, and South African Human Rights Commission. A total of 426 million over the medium term to intensify the fight against corruption and ensure sufficient capacity for the investigation and prosecution of criminal cases emanating from the State Capture Commission has been set aside. Amongst others, this will allow the independent directorate to appoint an estimated 90 staff members in a permanent capacity. Legal representation is an indispensable part of access to justice. Legal Aid South Africa is a critical institution which ensures the indigent in our country access justice. We welcome the report that an amount of 34.3 million is reprioritized to Legal Aid South Africa over the medium-term period to capacitate the 6 newly established specialized commercial crimes court in Limpopo, Mpumalanga, Northwest, and the Northern Cape. To strengthen the NPA's capacity, an additional of 1.1 billion will be allocated over the medium term. Land dispensation, racial segregation, discrimination, political exclusion, and all general socioeconomic under the development are some of the factors the apartheid system has. The rippling effect of the 1913 Native Land Act still exists. Therefore, there can be no justice without land justice. We welcome the transfer of the legal representation component from the Department of Agriculture, Land Reform, and Rural Development to Legal Aid South Africa. This will assist the indigent who seek land justice. Chairperson, as I close off, allow me to use a quote by the Chairperson of the Constitutional Assembly, President Ramaphosa, who on the occasion of the signing of the Constitution said, "Today marks the legal transition to a constitution that represents the will of the overwhelming majority of the people of this country. It's one law for one nation, a document that commits not only the government, but every single one of us to the values that have been disregarded in the past, to human rights, fair, decent treatment for all, to democracy and government that is accountable to the people, to tolerance of our differences and appreciation of our common humanity." Therefore, Chair, House Chairs, I close off. The ANC supports the budget vote. I thank you.
Thank you, Honorable Kgomotsora Molebeng. I'll now recognize the African Independent Congress.
Thank you, Chair. Chair, this budget vote must be prefigured in our commitment to bring about a just social order for our people. To succeed in this, institutions supporting democracy must be vigilant against abuse of state power. The Office of the Public Protector must serve the public and not be drawn to wasteful litigation on matters that are patently frivolous. The Human Rights Commission continues to perform its work with abiding clarity and commitment. The NPA's conviction rates must be sustained through a recruitment drive of young, skilled lawyers. The Legal Aid Board must be capacitated and restructured to allow for the outsourcing of skilled personnel in the private sector. Honorable members, we are regrettably concerned that the SIU is reportedly owed millions of rand by government departments. The department must look into this matter urgently. The progress of corruption matters referred to the NPA is under our radar. We are closely monitoring this process with keen interest. We are not moved, Honorable Chair, by the work of the department to giving full effect to the TRC's reparation findings. This is but one area which has stalled since 1994, and the department's reparation section must be brought to life. We are equally not pleased with how the department has responded to constant attacks against the judiciary. In closing, Honorable Chair, we call upon the department through the NPA to repatriate the remains of our liberation fighters who have still not been brought to home to rest. We therefore, Honorable Chair, support the budget vote. Thank you.
I now recognize the National Freedom Party. Sheikh Imam. Honorable Sheikh Imam. I pass. Honorable Werner Horn, you are recognized.
Thank you, Chair. Many vulnerable South Africans are dependent on the justice system to access funds needed to put food on the table. Maintenance money, guardian fund payouts, collection of debts, and restoration payments ordered by our criminal courts typically enable beneficiaries to merely survive from one month to the next. The proper functioning of the justice system of any country is also a precondition for the type of investor confidence and economic growth our country desperately needs so that jobs can be created, poverty could be reduced, and in simple terms, so that hunger and destitute can be prevented. This debate, Chair, takes place not only within this context, but also within the context of a very serious regression during the state capture years in the capacity and performance of every single institution except for Legal Aid South Africa, benefiting from this budget vote. 3 years into our current 5-year term, it unfortunately would seem that we are only seeing a tinkering around the edges of crumpled, keeled over and ever ailing institutions. A few examples. Problem number 1, a fiasco of bad advice, poor litigation outcomes, money wastage and possible corruption at the state law advisors. The identified solution, appoint a Solicitor General, heads of offices and ensure policy reform. The outcome, appoint only an acting Solicitor General, causing hesitancy and preventing bold, decisive moves. Appoint heads of offices, but hamstring them by showing no urgency on policy reform. Problem number 2, near collapse of master's offices. The identified solution, appoint a new chief master and heads of offices, seemingly without agreeing on relevant and urgent interventions. The continued outcome, long queues, lost documentation, non-responsiveness and poor communication, massive delays, and in many cases, a state of paralysis in the administration of specifically deceased estates. Problem number 3, court buildings countrywide operating in a state of near physical collapse, while court managers, justice officials, and public works officials all continuously busy themselves with the identification of the need for major maintenance projects, the implementation of which, unfortunately, which is as rare as Bafana Bafana qualifying for a soccer World Cup tournament. The consequences: Groundhog Day for officials who continue to work in an environment not fit for purpose, while continuously wasting time re-identifying urgent maintenance needs and pleading for implementation. The identified solution, as confirmed again today, the Minister is that he has assured us himself on a continuous basis, having talks about talks with his counterpart at the Department of Public Works. Problem number 4, millions of rands thrown towards the development of an electronic integrated justice system over the last 15 years, a project which languishes from the one insignificant lateral milestone to the next. The identified solution, colleagues, have no fear. An IJS board comprising, unfortunately, of the very same stakeholders that have been part of the project from the start has now been established, which will, the Minister strongly believes, ensure that this system will now rise like a phoenix and soar like an eagle. Problem number 5, an implosion of governance on management level at the Department of Justice. The identified intermediate solution, appoint a new Director General. Unfortunately, without any parallel process to identify the gravest of risks facing the department and acting on them. Further outcomes: a massive cyber ransomware attack, a hack, complete annexation and lockout from the online system of the department, followed a few months later by the contract for the maintenance and operation of electronic court recording technology coming to an abrupt but foreseen and avoidable end, causing wholesale damage to case flow, the ballooning of the criminal court backlog roll, frustration, suspicion, and secondary trauma to victims of crime. The further identified solutions: in respect of the IT systems, at first a frank admission by the DG that systems will need to be rebuilt from scratch, partly due to the impact of the hack and partly due to the inadequacy of the systems previously introduced, but then followed only a few months later with an assurance and insistence that all data has been recovered, all functionality has been restored, and that the old system is really not a bad one. The court recording technology: after this system being in a self-induced coma for nearly a year, the previous contractor is now reviving and nursing it on a temporary basis. Why no emergency extension of the initial contract was entered into with this contractor remains a mystery wrapped in a riddle. Problem number 6. Very little happening to prosecute corruption, theft, and money laundering that happened during the state capture years. The identified solution: strengthen the NPA and set up an investigative directorate. The unfortunate outcome: promises of seminal prosecutions within the next 6 months, which are regurgitated, repackaged, and re-announced every 6 months. Minister, this is the reality. The backward slide of this department is too big to think that you can tinker and doodle it into success. Wholesale structural changes needs to be made in respect of how we maintain and manage court buildings and collateral facilities, and how we manage contracts. Capacity and expertise will have to be added where it's needed on the simple basis of merit and merit alone. A real sense of urgency will have to become part of the executive and management culture of this department and its entities. And in the final analysis, you will have to heed the call by the Portfolio Committee and take up the fight against continued budget cuts to this department and its entities. For if this department and its entities continue to fail, South Africa will not be able to succeed. Thank you.
Thank you, Honorable Hall. Both Honorable Magwanishe and Honorable Ramulibeng were generous and saved 1 minute each, which will now accrue to Honorable Xola Nqola. And I now invite Honorable Xola Nqola for his 15-minute platform.
Thank you very much, Chairperson. Please allow me to have my video switched off for connectivity and audibility issues. I saw Honorable Mulder and Honorable Jafta were cutting, so I don't want to fall into the same trap. Chairperson, allow me to extend my greetings to the ministers present and the deputy ministers, the management of the department, the members of parliament, and South Africans at large. Chair, I want to begin by saying the beauty of our justice system is the application of the rules of natural justice, the well-known audi est alteram partem rule. This therefore means, for the purposes of this meeting, that if an office of the public protector finds a certain honorable Xola in the findings and in the remedial actions to have committed some wrong, part of the remedies available to Honorable Xola, who is part of the recommendations and the findings, is taking that report for review if they are not satisfied in the manner in which the investigation was done, which this is the case, Chair, in the matter relating to the Premier of the Eastern Cape. Want to plead with all honorable members to allow the courts to do their own work without any interference, without any doubt and aspersions having been casted against the courts. So, Chair, I wanted to start with that point. Secondly, Chair, the National Assembly has established a committee following a motion by the DA Chief Whip and following a report by the independent panel. The National Assembly established that committee in terms of Section 194 of the Constitution. The committee is established for the purposes of fact-finding into the allegations against the incumbent public protector. It is, in my view, very wrong for honorable members to want to cast aspersions and cause doubt to the work of the Section 194 committee, particularly that the committee itself has vocally been saying there is no predetermined outcome. We are here for fact-finding purposes. We'll then come back with the report to the National Assembly. Fortunately, Honorable Yako, her Supreme Leader is part of that committee, so maybe she will be able to understand the works and the work and the process that the committee ought to follow. Chair, the ANC rises in support of Budget Vote 25, Justice and Constitutional Development. Many countries across the world were faced with the ravages of the coronavirus pandemic, which not only robbed us of loved ones, but also crippled the economy. The coronavirus pandemic came at a time when we, as a nation, were still seized with the fight against gender-based violence and femicide, whose foundation is patriarchy and sexism. Almost every day, we learn of various and most gruesome acts of violence perpetrated against women and children. The war waged against the bodies of women and children is relentless and is at such an heightened level that GBV was declared the second pandemic. GBV goes against the ethos of the Bill of Rights. It is a serious human rights violation with major social and developmental impacts for survivors of violence, as well as their families, communities, and society at large. On an individual level, GBV leads to psychological trauma and can have psychological, behavioral, and physical consequences for survivors. In many parts of the country, there is poor access to formal psychological or even medical support, which means that many survivors are unable to access the help they need. Families and loved ones of survivors can also experience indirect trauma, and many do not know how to provide effective support. The Presidential Summit Against Gender-Based Violence and Femicide, which was held in 2018, resolved, amongst others, to fast-track the review of existing laws and policies on gender-based violence to be victim-centered, and that ensure all other relevant laws respond to gender-based violence. Implement the recommendations that have been identified from reviews and address legislative gaps, and revisit and fast track all outstanding laws and bills that relate to gender-based violence. President Ramaphosa expressed the country's commitment to addressing the scourge of GBV and announced the emergency response plan to address GBVF, which includes strengthening the applicable legislative framework. The legislative arm of the state was then seized with the duty to create laws to this effect. Last year, both houses of parliament considered and passed what is commonly referred to as the 3 bills on gender-based violence. Making it a good of his commitment, the president assented to laws that strengthen fight against gender-based violence in January this year. These pieces of legislation are the Criminal and Related Matters Act, Domestic Violence Amendment Act, and the Criminal Law Sexual Offences and Related Matters Amendment Act. The cornerstone of Criminal Law Sexual Offences and Related Matters Amendment Act is the National Register for Sex Offenders. The National Register for Sex Offenders aims to stop the spate of incidents against children and people with mental disabilities. The Department of Justice reported that the number of sexual offences courts established at designated courts would be an indicator of increased access to justice services. Further, it was reported that 30 million would be allocated to designate 150 additional courts as sexual offences courts and improve the management of the National Register for Sex Offenders. An amount of 49 million would be to upgrade all justice buildings to be accessible to people with disabilities. It was also reported that as a mitigating factor to the risk of delay in establishment of sexual offences courts, resulting in perpetual victimization of victims, designation or regional courts where the sexual offences court must be established. The target for the number of sexual offences courts established at designated courts has been increased to 80 for the 2022-2023 financial year. Honorable Chair, the National Development Plan states that safety should be measured by the extent to which the most vulnerable in society feel and are safe from crime and the conditions that breed it. Safety refers principally to the state of an area and is determined based on the real and perceived risk of victimization. Unsafety, therefore, refers to areas characterized by the significant prevalence of violence and crime. The main objective of the National Democratic Revolution is to attain a non-racial, non-sexist, united and prosperous society. While there has been immense progress in the emancipation of women in South Africa through legislative and other means, since the advent of democracy, women remain disproportionately represented among the country's poorest. Women are still in the lower rungs of the economic ladder. The gender divide is wide. This makes the ground fertile for patriarchy and the subjugation of women to thrive. Economic empowerment is a critical factor which contributes to achieving gender equality. Unleashing the entrepreneurial potential of women, which drive growth through innovation, education, training, and job creation, are some of the most effective ways to ensure lasting empowerment. To quote Thomas Sankara, when he said, and I quote, "The revolution and women's liberation go together. We do not talk of women's emancipation as an act of charity or out of a search of human compassion. It is a basic necessity for the revolution to triumph. Women hold up the other half of the sky," close quote. Chairperson, notwithstanding all the challenges encountered, we appreciate the report that gender-based violence and femicide is a priority crime in South African police services. We acknowledge the department's efforts to implement its turnaround strategy to deal with the DNA backlogs. This is critical for the collection of evidence in rape and GBV cases. It has been reported that through the ministerial interventions, by February this year, 17 critical contracts for DNA consumables had been awarded and forensic laboratories capacitated with 19 interns to fill critical positions. 40% of human resources are dedicated to addressing the backlog of 60% of human resource is dedicated for incoming cases. It was reported that between April 2021 to 10 February 2022, 196 persons accused of GBV were handed down 272 life sentences. The ANC government is taking a collaborative approach to ensure that no effort is spared to reach out to survivors and to address this gouge. For urgent counseling of survivors, the Department of Social Development has established a 24-hour gender-based violence command center, which offers trauma counseling and assistance to survivors. It can be conducted on 0800 428 428, and I repeat, 0800 428 428, or people can send a please call me by dialing *120 *7867 hash. I repeat, *120 *7867 hash on their cell phones. Chairperson and compatriots, it is important that I, as a man and a public representative, take a stand against gender-based violence. Gender-based violence is, after all, a problem of male violence. It is mostly men who are rapists and perpetrators of domestic violence. As men, we should also be playing a more present role in our families and communities, exhibiting healthy and positive masculinity as opposed to toxic and destructive masculinity. As men, we must call each other out and follow through when issues of GBV come to our attention. We must never look away when injustice is committed, whether it is in our families, circles, organizations, or communities. The fight against GBV cannot be fought by women alone. Everyone must join in the fight and will win if we work together. It begins with me. Honorable Chair, let us remind the Honorable Horn of Politics 101 or Leadership 101, that leadership can never have a focal point of problematizing everything. Leadership must lead by example. Leadership must be a solution-based kind of leadership, not problems this, problems that, problems this. The ANC supports this budget vote, Chairperson, and I thank you very much.
Thank you, Honorable Ngola. I now recognize the Honorable Minister. Unfortunately, I don't have an upgrade for you. The minutes are allocated, Honorable Mamula.
Thank you very much, Honorable House Chairperson. And I agree with the observations from the Honorable Chairperson of the Portfolio Committee on the issues of infrastructure. It's an issue that we're all working together in both the departments to deal with the issue in terms of the maintenance, in terms of the devolution of the mandate, and then also that it must be followed by the budget. And also on the issues that relates to the court backlog that we all have to address. And as the Deputy Minister has said, that assessment falls within the purview of the judiciary, with us giving administrative support. It is unfortunate that some members continues to attack institutions of constitutional democracy. And it's shocking that in their attack, they are being factional, attacking the courts and singling out certain judges without any facts, without any basis, just only armed with conspiracy. No facts, no reality, and nothing. And such kind of conduct is very dangerous in any constitutional democracy, to cast aspersions on important institutions without any facts and without any evidence and being factional. You cannot isolate just the courts and want to protect certain institutions. The protection must be afforded to all institutions of our constitutional democracy. And those to show that it is not informed by any facts, Honorable House Chairperson, for example, they do not want to acknowledge that the NPA and the Hawks are prosecuting on the Tongati matter, which is a white collar crime, which mostly white males that are being prosecuted, which shows that the NPA prosecute without any fear, favor, or prejudice. neither do they look at any color. They look at the facts of the matter. They are informed by the evidence. They are not informed by any minister or politician, neither will any organization inform them to prosecute or not to prosecute anyone. And also, even the opposition, they must know that when you want to instruct the NPA to prosecute anyone, you are also interfering with their mandate. It's not only if it's the minister. So there is no organization here in Parliament, Honorable House Chairperson. Maybe they may need to relook at the NPA Act themselves. You cannot instruct the NPA who they must. Even myself, I cannot do so. And even yourself as members of Parliament, you should resist and desist from the temptation to instruct what the NPA must do in terms of prosecuting anyone. Allow them to do so, informed by the facts, informed by the evidence, informed by the law in front of them, and not by any political statements and pressure. And I want to also, Honorable House Chairperson, agree with Honorable Msimang that we need to deal with the issues that relates to the Master's Office. We must respond to these issues because they affect the day-to-day delivery of services to our people. And some of them, the Deputy Minister has already spoken to. And I'm not surprised, as usual, by Honorable Mulder, bias and also unsubstantiated and criticism that is not informed by anything except the political views of his organization. And I'm not shocked that they will never support this budget because this budget is for all the people of South Africa. It's not for a select few. It's not for any segment of the population. It's for all South Africans for the benefit of everyone, black and white, colored and Indian. Honorable Mulder would have preferred that we should only allocate the budget to only a particular group of people in the country, which we will never go back to. Now, South Africa belongs to everyone, and that is what we work for. And we also want to clarify on this issue of the Solicitor General that we continue to give support to the Office of the State Attorney and policies to turn around the institution. Some of them already before Parliament, which we're hopeful will enhance the work of the State Attorney, and others are already in the offing. And in our view, we are turning around that institution. It's only those that refuse to see, that do not see that the Office of the State Attorney is being turned around. And indeed, Honorable House Chairperson, it is also deliberate closing of the eyes by Honorable Horn, who does not see that there has been an improvement in the performance of the department from 66% to 79%. It's a huge improvement that this House should be able to acknowledge, and which we do believe that more can be done to improve. But to say that there is no improvement, there is a decline, it is not informed by the outcomes percentage.
X and the whip, I can see you carrying an X. Let me take that X away.
No, thank you, Honorable House Chairperson.
Thank you. I now remind members that the debate on cooperative governance and traditional affairs will start at 16:30. This concludes the debate and the business of this virtual mini plenary. The virtual mini plenary rises. I thank you, members.